representing Ms. Turner. And I see Mr. Reed's there.
Sorry, Your Honor, there are jet planes flying by. It's hard to hear.
All right, great. Mr. Reed's here, and I see that Ms. Turner is here. And then let's see if Mr. Hamir is on the line. Mr. Hamir, are you on the line? Or anybody from his office? Okay, I see that Ms. Looney is here representing the state. And any communication from Mr. Hamir if he's on his way or if he's having difficulties? Anybody hear from him?
Yeah, I don't see.
We would actually be asking for a continuance today because we were not served with these motions and there is a state interest involved.
Okay, all right. All right, so here's my considerations at this point. Ms. Looney has made a motion to continue the matter. Mr. Hamir is not here to respond. Mr. Reed is here, ready to respond. And then I have another matter, the Mortensen matter, which Mr. Lee, who is covering for Mr. Morgan, is in 2 other dockets and won't be here for a little bit. And so that's the end of the matters that are slated for today. So I guess the one proposal is to just wait maybe 5 minutes. Maybe somebody could ship off a quick email or text to Mr. Hamir or a phone call to see if he's coming. We could hear the Turner Day motion to continue and whether that's granted or not, proceed. And then hear the Mortensen matter after that. I'm open to other ideas.
Your Honor, we're open to whatever you want to do. We understand the state's issue, and I think we're fine if we shift this to another day.
Okay. Well, let's do this. It's 9:04. Let's come back at 9:10, and if one or both of you could maybe just ship off a text or an email or a phone call to Mr. Hamir's office, see if he's on his way, and come back in 5 minutes. Okay, thanks everybody for your patience. We're back on the record. It's 9:12. Just touching base, Ms. Looney and Mr. Reed. Any contact or communication from Mr. Hamir?
Your Honor, my assistant is attempting to make contact. She's on hold. I'm trying to discuss the case with an assistant at this point.
Your Honor, I did hear. I got a response. Ms. Gunner is appearing for Mr. Hamir, and she understood that the hearing was at 1 o'clock and not at 9.
Okay.
She's in another hearing. She said she'll be here as soon as she can.
All right. All right. That's a little unsatisfying, but thank you for the effort and reaching out. That's great. I appreciate that. Both of you reaching out. Do you know, I guess you don't know what the timeframes of the completion of that other docket, correct?
The completion of what?
The other docket that Mr. Hamir's associates in.
No.
Yeah. Well, let me ask both parties what your preference is. There's a motion to continue the matter. The parties are the other side isn't here, nor is counsel. Apparently, they were planning on 1 o'clock today. So one option would be to grant the motion to continue 1 week and inform the other party that that's what happened, rather than making everybody wait. Or we could wait for an unspecified time, which is not my favorite because I think everybody's just kind of your time's valuable, my time's valuable, clerk's time's valuable, and then just so that's. Any thoughts on that? The approach to take?
Your Honor, the state's request would have been to set this to September 12th. We already have the final Guardian Leiden report hearing set for that date. That would give the state time to respond in writing and for the other parties to file replies if they felt that they needed to do so. I do see that Ms. Corey is present, so I suppose we could ask her if the 12th is still a good date for her to have that final report completed.
Okay, thank you. Ms. Corey?
It sure is.
Okay. All right, Mr. Reed?
Well, Your Honor, I think the only urgent issue at this point is we're requesting additional support given that the sale of the house has caused a hardship. And our request was to revert that back to when we filed that request. again, it's just that hardship that we're continuing. We don't have an objection. We understand Ms. Looney's position. I apologize, Ms. Looney, we didn't receive documents, but again, that's our only concern.
Okay.
But otherwise, we're available on the 12th.
Okay. All right. Let me just double check the. Oh, there's Ms. Gunnell. Okay, let's go ahead and address that the Turner Day matter. Ms. Gunnell is joining us now. Thanks, Ms. Gunnell, for joining us.
Absolutely. I do apologize. I was in another hearing and I was under I think there was 2 notices of hearing we received and we had the wrong time. I was under the impression this is at 1 p.m., but I definitely apologize for my tardiness.
Okay, well, thank you for being here. I appreciate that. We'll note that Mr. Day is on the line with us. So prior to your arrival, Ms. Gunnell, Ms. Looney, on behalf of the state, made a motion to continue, citing that she hadn't been served papers related to the motion related to child support. And so she had requested a continuance to September 12th. And so then that's when we started reaching out to Mr. Hamir, yourself, and then Ms. Corey had indicated that she's available on the 12th. Mr. Reed had indicated that he understands the state's position and that his biggest concern on behalf of his client is that some relief of not receiving support payments that are important for Ms. Turner. So that's where we kind of left off, and then we were just going to go ahead and move it to that date, and then you popped on, and so I think we kind of.
I do have a hearing at 9 a.m. on the 12th, so I would be available for a 1 p.m. hearing or any other time that day.
So when you say you have a hearing at 9, is it a docket matter that would take a shorter period of time than all morning, or is it a full morning?
It's just a docket hearing, a domestic calendar, so I could be heard in 10 minutes. It could take 2 hours. I'm not exactly sure.
Okay. Well, let's. I think it's important that I think it's important to have continuity of the judicial officer. So I don't want to switch it over to a different docket. So let's go ahead and then move it to September 12th, where it's already been set to hear Ms. Corey's guardian ad litem report, and then we can address all issues. Ms. Looney can receive the documentation and have an opportunity to respond, and then you all can respond if you want to respond to her response.
Absolutely.
So if everybody's comfortable with that, we'll move it to September 12th at 9 a.m. and we'll hear the matters at that time. Okay, so that brings us to the Mortensen matter. Mr. Lee had communicated with the court earlier. He indicated he's in 2 different dockets this morning, so he's going to get here as soon as he can. So Ms. Bliss, you're here and you're representing Brenda Mortensen, correct?
That is correct.
Okay. Just so you're aware, Mr. Stephen Mortensen is in the courtroom. He's present. And then we're just waiting for the arrival of Mr. Lee.
Okay.
So maybe what we could do, we could check in 10 minutes at 9:30, see if Mr. Lee has experience. If he comes in a little bit earlier, would you be available, or do you want to just shoot for 9:30? Okay.
I can stick around, Judge. Whenever he appears, I can appear.
Okay. Well, let's just kind of set a time frame of 10 minutes. We'll come back at 9:30, touch base, and then we'll go from there. We're here in the matter of Brenda Mortensen and Stephen Mortensen, 223-38808. We're here on a continued pay or a peer docket related to spousal maintenance. Mr. Lee was appointed, I think, on the 15th of August, and he's here. And I just want to touch base with him to see if you've had an opportunity to confer with Mr. Mortensen.
And Your Honor, I and Mr. Morgan have had some opportunities to talk with Mr. Mortensen. We are aware that he's filed paperwork essentially going against the original order, but he is trying to take care of his obligations under that order. He brought with him today, it looks like a deposit receipt from Chase. It indicates that the transaction of $1,300 for the maintenance will go through as of next week. He also brought with him checks for Ms. Bliss as far as attorney fees. So it does appear we're attempting to cure, though we haven't successfully done that yet. What I would just request, given the recency of my appointment, as well as the fact that he is making progress on the payment, if we could set perhaps another review in a couple of weeks, make sure that those payments go through, and then we can potentially strike this hearing.
All right, thank you. Ms. Bliss?
And Your Honor, I think you're very aware of my position in this matter. We've been before the court for the last 8 months on this contempt issue, a frequent pay or appear docket. Mr. Mortensen has come in person. This is his 3rd time in the last month. Not one of those times has he ever brought a check to my office. Not one of those times has he paid my client the amount that's owed under the current order. I was prepared to tell the court today that he did make a $200 payment, which is consistent with his past practice. And that payment was made on August 15th. While it's great to hear that he's got those checks, I think I still believe that jail time is appropriate, at least for nothing else than to teach him a lesson that we've been before the court numerous times. He's had plenty of opportunities, but for today's hearing of impending jail time, those payments were finally made. I'm concerned that if Your Honor doesn't follow through with that fair warning that both you and Judge Warning have given him the last month, that this is just going to be a continuing issue, and we're going to be back before the court in that review hearing in a couple of weeks, as Mr. Lee has requested, and we're going to be in the same position requesting the support be paid in full again. But I'll defer to the court. I will also ask the court for another contribution of attorney's fees. Again, this is the 3rd hearing in the last month that my client has had to pay for my attendance simply to get Mr. Mortensen to comply with the court's order.
Thank you. Did last week, I don't think Judge Warning awarded any attorney fees for the last court appearance in which he was present?
No, Your Honor. Mm-mm.
Then the prior one, there was not any award of attorney fees, correct?
Correct.
Okay.
Your Honor, could I briefly respond?
Yes, please.
I do just want to indicate the substantial change in circumstances that's occurred recently is my client has taken out a loan to essentially pay these fees. He's indicated that the interest rate is quite high. Frankly, I've been appointed at state expense. I don't believe my client in normal circumstances is capable of making these payments, but he is trying to stretch and use whatever resources he has to try and become compliant. So again, I do believe things have changed in the recent days.
Well, let me just share just a little bit of kind of my analysis of what's going on here. So there was a spousal maintenance order entered in September of last year, 2022, an amount of $1,500. Since that time, there was difficulties, and in January 10th of this year, there was the pay or appear order to appear on a regular basis to see why Mr. Mortensen was paying or not paying, or not paying. If he wasn't paying, he would explain why. And there's been a consistent pattern of non-compliance. He's been paying roughly $200 a month for many months. And when I took a look at this, I thought it's very interesting that he received a $5 an hour pay increase on January 1st of this year. So his gross previously was $4,800, and now it's about $5,800. So his net income increased at least $536 a month. And there was still no increase in maintenance being paid by Mr. Mortensen. Also, there's no showing of any belt tightening, if you will, because it's very difficult when people go through divorces. There is not enough to go around, but yet there needs to be at least some showing of belt tightening. And so what I heard from Mr. Mortensen last time is that he's concerned about his health, rightfully so, because he's diabetic, and that he spends $350 a month for work lunches, which if a person is really interested in complying with a court order, they're going to make some adjustments to that. And that means that maybe they would cook in the evening and bring their food for the lunch the next day. And they could dramatically decrease that cost for the work lunches. Recreation, the same thing. Mr. Mortensen talked about fishing, how that was really important for not only his mental health, but his physical health. He said that was very important to him, but yet there's been no showing of any belt tightening there. There's an indication that his vehicle, it's important where he lives to have good tires on his vehicles to get to and fro. And yet there's still a $700 a month in his budget for gas and auto maintenance. No showing of any belt tightening. So if there was a reduction of even 25% of those 3 items, that's $312. And if you add that to the net income increase of $536, that's $848 a month of extra money. So you add that to the $200 that you've been traditionally paying, that's roughly $1,000. There's been no showing there's been any effort to increase the even nominally the child's or the ordered maintenance. So even if there's a showing of like $225, okay, this month I'm going to try $230. There's been nothing. Zero effort, zero showing of any belt tightening, zero effort that the net income increase that he's received has gone towards satisfying his obligation. How long do you think you should stay in jail until you get the message, Mr. Mortensen?
I don't think that I should be in jail. I did go and get the personal loan. It's large enough that I can pay the back owing. And moving forward, if it's still the case that I owe $1,500 a month, I can come close to that, I believe. I'm, after talking with Mr. Lee, Mr. Angelico, and Mr. Morgan, I have been schooled, and I understand that this is a court order and that I need to take care of it until it is resolved one way or the other.
The $1,300 that was scheduled to be paid next week, do you have what Mr. Lee had mentioned? What date is that supposed to go out and be transferred?
It's already in Chase, and they are holding it until the 30th. I put it in yesterday.
So when you say they're holding it till the 30th, what does that mean?
I have no idea. That it's on the receipt that I got from Chase, that it just says date when available, 8/30/23, 2023.
Is that because it's a deposit clearing time frame?
I really have no idea, because I've never, in any of the deposits that I've made before, it's never come back like this. It's a money order deposit.
And Your Honor, I will indicate on the receipt above that, it says notice of delayed deposit availability. So I believe that is what is indicated on this receipt. It may just be a value situation. If too much money is going out, they might just delay it automatically.
Right. Okay. All right. So in any issue related to contempt, there needs to be a willful and intentional failure to abide by the court's order, which was from September. So since September, there's been a shortfall, percentage-wise, pretty significant. I mean, the $200 is less than 20%. So it's probably 15-17% of what the court had ordered. And there's been no corresponding increase, notwithstanding pay or peer appearances. There's not been any movement at all for the prior two hearings, and now we're here. So there's an issue about upholding the integrity of the judicial system. There's an anticipation that the courts, when they order something, it'll be followed through. And there's concerns also that if I don't follow through with what we talked about, the jail time, is that integrity or the authority of the court is somehow diminished. And it's not necessarily, it's not this court, meaning it's the entire judicial system. I'm very loath. I don't think I've ever sent anybody to jail for failure to pay. I'm pretty darn lenient with that. What's concerning in this case is that there has been a significant increase in net income, and there's been no belt tightening. I just haven't seen it. And there hasn't been any showing of, if somebody said, hey, I am scraping by, I am doing this, I'm recycling aluminum cans. I mean, some showing that there's an effort to increase the amount that the court ordered. And it's not even coming close percentage-wise of what the court had ordered. And Mr. Mortensen has the opportunity and has had the opportunity to bring a motion to modify that spousal maintenance award. If he felt that it was incorrect, there's opportunities to appeal, there's opportunities for reconsideration. None of those have happened. And so that's why I asked the pointed question to Mr. Mortensen, how many days in jail does he think it'll take for him to understand that this is serious business? When the court orders something, there needs to be effort. There needs to be effort expended to comply. And I guess that's what I'm seeing now. It's almost a year later from when the court ordered this. So there's been plenty of time to adjust schedules, adjust income, adjust spending patterns. And I recognize that spending patterns are difficult. There's obligations that we all have, and it takes time to adjust those. I recognize that. And yet at the same time, there's been no showing of adjustment. And to me, that's the most concerning part, is that's why contempt is there. It's an effort to help people change their behavior so that they come into compliance with the court order. That being said, there's a indication that there's a personal loan that's been taken out. I don't know the exact dollar amount. Mr. Lee, do you know the exact dollar amount?
I don't.
It was, it came to about $7,500 after the origination fees were taken out.
Okay.
And I do understand that this is an obligation that was put onto me, and I'm trying to make adjustments. As of recently, I don't think I really understood how serious it was, but I do now. And I am trying to make the adjustments to get the back ordered monies paid, and moving forward to adjust my spending and my budget to accommodate that.
Can you share with me what some of those adjustments are?
Well, like you said, preparing lunches beforehand, the night before, or get up right up in the morning to do it in the morning. And not doing the truck maintenance and stuff is pretty well taken care of. So that will be cut. Gas, just not going, if I'm going to go fishing or something, not going as far to go fishing, go fishing closer to home, so I'm not spending the gas. Things like that, just like you said, tightening up and meeting this obligation first, I guess.
Okay. All right, so I'm going to award an additional $500 of attorney fees for the 3 instances in which we've been here addressing this in favor of Ms. Bliss's client. There's been multiple payer appearances, dockets, and I think the idea is that sometimes that can be a double-edged sword. We have people come in, okay, I can't pay, and so we kind of nurse it along and say, okay, when are you going to pay? You didn't pay this month, and it gives kind of maybe a false sense of security that pattern is going to continue. That's one way to view it. The other way to view it is like, hey, look, this is an opportunity. We're saying you need to pay this amount, and we've visited on a monthly basis for a long time, and so that's why I say it kind of cuts both ways. One, it may give kind of a false sense of security, like, okay, this is going to continue, and everything's going to be okay. And on the other hand, it shows kind of an exceeding patience, a level of patience and forbearance of exacting what the court had ordered previously. I don't think I can go any further. I'm going to send you to jail today for 2 days. You'll be released tomorrow in 48 hours. And that's just a clear sign that this behavior must change and that there needs to be compliance with the court order. So I'm going to invite a deputy to come up to take you into custody, and then you'll serve the 48 hours. And then you'll be released, and then we will set this for a review on the 5th of September to make sure that payment of the $1,300 has gone through. And that's the payer of the peer. So take a seat, you stay right there. The deputy will be up and then take you into custody. That'll conclude the hearing.
Would Your Honor be willing to prepare a bench order for that $500 attorney fee judgment, or would you like me to prepare one?
I'll do it.
Okay, thank you, Judge.
All right, that'll conclude the hearing. Mr. Mortensen, please remain in the courtroom until the deputies come and taken into custody.
And Your Honor, his vehicle's in the parking lot. Does he need someone to come pick that up?
The vehicle?
He has a vehicle that he drove here in.
And I also have my medications in the vehicle.
I think the medications are important to get. So I've never seen any, well, I've never heard of anybody being towed from the Hall of Justice, not to say that it hasn't happened. You may give consideration to moving your car to the south parking lot. Because there's the
here on
one
the
that's
side
right
of
in
the
front of the
building.
river. But if you're south of the parking lot or south of the building, that's generally, I think, a more forgiving, and you're not going to draw as much attention. And just park it in an area where it's well lit underneath a light. So once you've completed that, you'll need to be back in the building at 10 o'clock. So 10 o'clock, you'll need to be back here. The deputy's here. So deputy, just so you're aware, this is Mr. Stephen Mortensen. I've held him in contempt, and I've imposed 48 hours of custody. He made a request to retrieve some medication from his vehicle that's parked in front of the hall.
Okay.
And I said, that's fine. And then he's also going to move his car to the south parking lot, and then he'll be back here at 10 o'clock
Okay.
to go into custody. And I don't know if you want to have that here in the courtroom, or if it'd be easier just at the
I'll meet him downstairs.
at the hot tub at the entrance.
The security again.
Okay. All right, we'll proceed in that fashion, and we'll review this on September 5th at 9 a.m.